A house in probate for sale refers to a property that is being sold as part of the probate process. When a homeowner passes away and leaves behind real estate assets, those assets typically go through a legal process called probate to determine how they will be distributed among beneficiaries or heirs. During this process, the court oversees the administration of the deceased person's estate, including the sale of any real estate owned by the deceased. Here are some key differences between a house in probate for sale and other homes for sale, along with some pros and cons. Pros: potential for below market value. In some cases, houses in probate may be sold at below market value, particularly if the heirs are motivated to sell quickly, or if the property requires significant repairs or maintenance. Court oversight. The probate process involves court oversight, which can provide a level of assurance to buyers that the sale is legitimate and that any disputes over the property have been resolved. Opportunity for investment. Investors may find opportunities in purchasing properties in probate, especially if they have the resources to navigate the legal complexities and potential for negotiating favorable terms. Cons: lengthy process. Probate can be a lengthy process, often taking several months or even years to complete. This can result in delays for both buyers and sellers. Uncertainty. There may be uncertainty regarding the condition of the property, the title, or other legal issues that could arise during the probate process, which may deter some buyers. Limited negotiation. The terms of the sale may be subject to court approval, limiting the ability of the seller or buyer to negotiate certain aspects of the transaction. Examples of houses in probate for sale and their terms. Estate sale. The deceased owner leaves behind a will that specifies how their property should be distributed. The executor of the estate, often a family member or attorney, lists the property for sale, and the proceeds are distributed according to the terms of the will. Intestate succession. If the deceased owner did not have a will, the property may be sold as part of the intestate succession process, where state law dictates how assets are distributed among heirs. The court may appoint an administrator to oversee the sale of the property. Dispute resolution. If there are disputes among heirs or beneficiaries regarding the distribution of the property, the court may intervene to resolve the matter. The sale of the property may be part of the resolution process. Tax liens. If the deceased owner owed back taxes or other debts, the property may be sold to satisfy those obligations. The sale proceeds may go toward paying off the debts before being distributed to heirs. Mortgage foreclosure. If the deceased owner had a mortgage on the property and failed to make payments, the lender may initiate foreclosure proceedings. The property may be sold through probate to satisfy the outstanding mortgage debt. Or maybe the deceased will be a dead ringer and come back to life.